Hi, this is Professor Chad McGuire, and welcome to this video lecture summarizing U.S. coastal and ocean zoning, summary of defined zones. By way of introduction, we can say that the different zones or distinctive areas of near coastal and ocean waters are fundamental to understanding policy dynamics. And it's important to point out that when we say zones, there are multiple ways of looking at this. There are natural zones. There are ways in which we can distinguish between, let's say, we call an intertidal zone. And normally that is defined naturally by an area that is subject to, based on forces of gravity, when the ocean has a tidal range between a high and low tide, it's usually defined as the area that exists between that high and low tide, that physical area. So it has a physical characteristic that's dependent on natural conditions to define, for example, the intertidal zone. And that's sort of a universal way in which we humans have, using nomenclature from, let's say, a natural science standpoint, try to understand and define these different areas. So we might call that, and of course, a beach, for example, normally is a sandy to rocky area, but is usually defined by unique characteristics that include sand and maybe sand dunes and some, depending on where you are in the world, some other unique natural characteristics that help to define these areas. And then, we have a number of ways in, for example, oceanography for defining the unique characteristics of different zones of the ocean. And we can geospatially define them as we move away from the coastline, in terms of, if you think of the surface, just the surface of the ocean moving further and further distance-wise from that surface, let's say from a coastline, seaward. And then there's also where you can start thinking about depth, for example, as you start moving down, and some of the characteristics that you might encounter as you move at depth from the surface of the ocean water, moving down in depth. And often zones are defined, they can just be defined by actual, numeric depth in meters, for example. So that's an equal measurement, a form of measurement. There are other ways to define those zones naturally, for example, by light penetration. Often we look at what happens. There's a photic region of the ocean, and that's where light fully penetrates. You get a lot of primary productivity as a result of that, because light's necessary for things like phytoplankton or plant-based organisms that exist, algae and other organisms that exist in the ocean. They require light as a mechanism for their own sort of growth. It's a source of food for many of them, and then forms the sort of basis of what we normally describe as a food chain. But we can think of the light penetration zone, and that's different. It's different in different parts of the ocean. It might be deeper in one part of the ocean or one area, same location, 30 meters off from shore, but the amount of light penetration in one area of the world might be different from another for a variety of reasons. The amount of primary productivity, for the amount of stuff that's in the water that can then prevent light, the amount of turbidity, the amount of movement of wave action and other things under the water that can stir things up and move things around, that can sort of create effectively like a cloud cover, and make light less penetrable as it moves down. But the point is, we can also identify zones naturally from these physical phenomena that are related to natural phenomenon. So you can have a photic region, a light penetrating region, a dysphotic region, a region where light is fading and less capable of penetrating, and then I think an aphotic region, or a region where there's no longer light availability, where it's effectively dark for most of the time, if not all the time. And this matters because there are species that are obligate or dependent on being able to access certain areas. The point is, there are many ways in which we can define these zones, right? This idea of zones or specific regions or areas. And what we're talking about here is we're really talking about defining zones that are in part, that definition is in part, some of those definitions take cues from the natural environment, but otherwise they are mostly political designations, political legal designations, human-based designations. So this is discussed in great length, in detail in other videos, and I will identify them, and I will have a link to the sort of playlist where you can see some of these others. And certainly if you've taken, for example, the Ocean Policy and Law course, most of these zones you'll have some sense of, because we've talked about them in different parts and different segments, getting into some of the details. But these are, what the point is here is to give a large summary, a holistic summary of all of the different zones. So instead of having them in different sections broken up into different portions, we're looking here at these sort of like legal policy that identified zones that are generally speaking, generally applicable. And what I mean by that is, even if, again, if we're talking about the United States, for example, different coastal states identify their coastal zones differently. It's a political designation. It has connections, obviously, to natural phenomenon, but Massachusetts defines it defines its coastal zone differently than, say, the state of Hawaii, which identifies all of its territory, all of its physical territory as part of the coastal zone. Massachusetts, even within Massachusetts, it defines different parts of its state differently in terms of coastal zone for purposes of identifying its quote unquote coastal zone. Most of Cape Cod and I think the islands, Martha's Vineyard and Nantucket, are all identified as coastal zone. The entire, like Hawaii, the entire area is considered a coastal zone. But as you move away from the Cape and you're not on the islands, then the coastal zone is defined differently. And again, you can review the materials if you're in the Ocean Policy and Law course, certainly the materials. If you're not, if you look at the lectures, the video lectures, some of the others, particularly the Coastal Zone Management Act, for example, you'll be able to see some of those details. But the point is, those definitions are different. So what we're doing here is we're trying to sort of just bridge what is common between these definitions to get a general sense overall, starting from the land all the way out to international waters. So we take law of the sea, which again is this is an international agreement amongst nations about how to define or how to have some common understanding of these sort of zones, so that we can then, from that understanding, have a framework upon which we can then begin to start developing universal norms, universal policies that apply to all nations, particularly when nations want to do things that interact with, that put their desires and their activities at possible conflict with other nations' desires and activities in areas where both of them might claim a right to these areas. What's happening right now, just as a quick aside, part of the introductions, as a result of climate change and some of the effects of climate change, particularly in the Arctic, a lot of the Arctic Sea that is normally under ice for almost all of the year, or has been historically for all of our important human development, it's recently, over the past couple of decades, becoming ice-free for a good portion of the year, and including completely ice-free, where it's creating sort of transit opportunities. So what that's done is that's created for many of the nations, that for all nations, but for in particular the nations that would claim portions that are their actual physical country is a coastal nation that abuts the Arctic. So you're talking about Canada, Russia, the United States, the Scandinavian countries, like Greenland vis-a-vis itself, and also related to Denmark. And again, some of the other European, Scandinavian countries that have physical locations proximate to these areas, but they all, so what that's done is the opening up as a result of the melting of the Arctic ice sheet, particularly the sea ice, in the Arctic Ocean is really opening up all of these sort of claims, and the claims are in conflict with one another because it's never been a viable route for transit, for maritime transit, certainly for cargo, but also for exploration and exploitation potentially of natural resources that exist under the water. So there's a good example of how this sort of conflict can arise where nations, for example, are all looking to the same place and identifying it as an equal resource, or a resource that they have rights over that they may or may not in relationship to another coastal nation. So just in order for us to get the sort of groundwork together. So if you're new, if you're listening to this for the first time, if you have no background, when we talk about zones here, we're talking about really political, legal, defined areas that move from nation-defined, national definitions, that's near water, to within obviously the borders of the nation, the land that abuts the ocean. From that nation's definition, and we're in US, we're going to use United States definitions for those early zones, to as we move out to sea, further and further out, where we start using international norms, particularly the framework of the Law of the Sea Convention, which many coastal nations, even if they're not complete ratified signatories. The United States is not a ratified signatory to the United Nations Convention on Law of the Sea, but it follows almost all of its frameworks. And you'll see that with others as well that are, but many, many nations, well over 180, I believe, are all signatories. Coastal nations are signatories, ratified signatories to the United Nations Convention on Law of the Sea. So it provides an important framework. And if you want more on that, you can then look at the United Nations Convention, our international law video that talks about some of these international legal frameworks as well in more detail. But so now that we have an understanding of what these zones, what we mean about distinctive areas, each of these zones has its unique and distinctive set of history and issues, and they're complex and the details matter. So we're not getting into the complexity and details here. We're just trying to get a holistic sense of all of those zones sort of put together and what that might look like. But those details are incredibly important. And knowing those details, if you really, so if to use an onion analogy, right? We're not getting deeply. Onions have many layers, so we're not peeling off all of the layers here. Far from it. We're just looking at the sort of superficial layer of the onion here to try to get a sense of all of those different zones. But if you really want to think and understand the context of these zones, you need to understand that there's a lot more detail that applies. So here, the other part is, as we're looking at that particular layer of the onion, we're looking at the United States, the major zones applicable to the US, both near coast and as they move out to the ocean. So some of that, if you're not thinking about or looking at the United States, some of that near shore stuff might be different depending on the country that you're thinking about, the coastal nation. But as we start moving offshore, particularly if that country adheres to or is a signatory to, a ratified signatory or just a signatory that follows the United Nations Convention on Law of the Sea, then most of those other zones will apply equally. But otherwise, as we are inland to near shore, it's mostly we're talking about US law and frameworks here. And just again, to reiterate, this is a summary, and summaries are really good. Summaries are great because they can help you get a big picture. If you're using the forest from the tree analogy, right, then the big picture is great because it helps us see that forest. It helps us see that large scale framework, which is really important because without that beginning, without that large scale understanding, it's really hard to start thinking of more detailed questions, to start delving into some detail in each of these and start understanding what that means in context, what some of this, anything that you're looking at. So this big picture really helps to give you a sense of, okay, here's a starting point. Here's where I can place the more, the more detailed issue that I'm now looking at. I can place it into this framework and start understanding it in some greater detail. The other side of that coin about summaries being good is summaries are bad because they often lack necessary details. There are no trees. And I just want to, again, make that abundantly clear because no one should rely on this video summary here as a mechanism to try to understand all of the complicated issues. It just simply is not, that's not the purpose. So, understanding the forest is great, but without the definition of the trees, you're limited in both your understanding of what it means, what these zones mean, and how they interact with any of the issues that might come up that you're interested in. And as a final matter, and I will put this, I think, at the end of the video, I'll make sure, I hope to have a link to the playlist in Ocean Policy and Law. So if you want to get any more of that greater context, again, there's context upon context. So, more layers of that onion will be exposed to some of these other videos, not all the layers. I don't know if we could ever expose all the layers, but more of those layers, more of that detail is provided to you. And I'll make sure that there's a link so you can look at, and they are, 4 or 5 or 6 videos where you can look at some of the, you look at the headings and you'll have a better understanding of just what kind of details they give you. Okay, so with that introduction, let's take a look at what we have here. So one good image, I think, with a lot of detail, and we can begin in the upland area. So this is an area, right, where we can say there's a distinguishing characteristic, this sort of arbitrary political line that has some connection to nature. But above this line, landward of this line, we have what's called the uplands. And in the United States and in many other countries, you have normal zoning. So you have private property, mostly. You can have public property, certainly owned by the state, et cetera. But let's just assume we have the issue where we have private property that is owned privately by a citizen or an individual. And that private property is subject to certain public restrictions, and that's zoning. So we, in the United States, zoning usually happens at the state level under the 10th Amendment to the United States Constitution, the reserved powers under our federalism sort of form of government between federal and states. States are sovereigns, but subject to federal sort of oversight and regulation, limited oversight and regulation. But anything that the federal government doesn't directly address is left to the state, and that includes under the 10th Amendment, health, safety, and welfare. And zoning has been identified under case law through our judicial system as a fundamental sort of health, safety, and welfare power of the state government. And certainly the states engage in statewide zoning, and then they also defer some of the details of that zoning to local governments. And in states, coastal states like Massachusetts, where I'm from and where I work, mostly they have something called home rule, and this is normal in a number of other states. And home rule says that, there are large-scale statutes, state laws that are on the books that help to set up large-scale zoning for the state, but then the detailed zoning is left to local zoning boards. The local individuals that live in local communities that are elected by those local communities or appointed by those local community members are the ones that are then empowered to do detailed zoning. Of course, that detailed zoning cannot be in violation of state law, right? So they can't zone in a way that fundamentally violates state law. They can work within state law. And usually go further, but not in any way that unnecessarily restricts an individual's rights. But those zonings, the dry land zoning is a very normal sort of regular, what's allowed to be done on this property, what can be developed, is it commercial, is it residential, is it industrial? You think of large scale zoning based on category, what kind of uses are going to be allowed here, and then other things, so how is this land primarily to be used, that kind of thing. And then there is a line, and that line, normally, if we're starting to look at the coastal zone, like I said, Hawaii, this property, any physical property in the state of Hawaii is considered part of the coastal zone. But for most coastal states, there is this part where the upland is not part of the coastal zone, and then there's some sort of designation. In Massachusetts, outside of the Cape and the islands, the designation is usually that begins the coastal zone is we look where there's water, we find where there's some major road, the first major road from that water, and then 100 feet from that road, that's where the coastal zone begins for Massachusetts. So it's very, it's a very sort of geopolitical sort of designation, because it's based on, if there's some developed road that runs parallel, that sort of thing. And it's not really based on some sort of easily understandable natural phenomena. But in many other places, usually there's this line of vegetation that separates the upland area from where you start looking at, let's say, a traditional beach. There's some sort of line of vegetation. And in most of these cases, that line of vegetation begins this notion of where the upland coastal zone. It's a unique natural feature, a common natural feature in many areas, not all, but in many areas, where you can begin to say that this is a physical characteristic that helps me identify where I'm starting to move, even in uplands, from non-coastal zone to the coastal zone area. And normally, in these areas, you have restricted uses. So, where you might have development, normal development anywhere in this upland without any other thing, with all other things being equal, once you start moving, and for coastal zone management purposes, protecting coastal zone resources, then once you get into this line of vegetation, usually there's restrictions on what a person can do. So I'm a private landowner. Most of the time I can still own this property. I might own it privately, but what I can do is limited once I hit this line. My capacity to do whatever I want is limited once I get into this sort of coastal zone feature area, once I'm in the coastal zone. Then moving from this line of vegetation, we move into this sort of sandy area. Let's just call it a sandy beach. I know beaches aren't always sandy. There's certainly for a number of reasons, there's rocky beaches, there's sea level rise, and as a result of sea level rise, there's less and less beach, even if there was a sandy beach, so on and so forth. But let's just assume that there's this sandy area. And then there's a distinguishing characteristic in the sand, and that is between, like we said, there's normally for diurnal tides, for where there's a tide, every 12 hours or so, at least in the northern hemisphere. It's different in different parts of the world where you are, but we know that because of the moon and because of gravitational forces and because of the Earth's rotation, normally there are tides. That means that the ocean moves in and then moves out. It's higher at some points during the day and lower at other points. Sometimes it happens multiple times a day. In some places it happens once a day, but let's just assume on a normal once a day, there's normally a tide that comes in, and it averages out because sometimes the tide is higher. Think of a king tide, for example, like a full moon, and sometimes it's lower, neap tide, where it's lower than the normal low tide, or it's higher than the normal high tide. There are all of these unique natural phenomena that cause variations from the average. But let's just say on average, there is a high tide, and then there is a low tide, and this line represents the high tide. So this is always dry sandy beach, and this is the part of the sandy beach that is exposed at low tide and that is underwater during high tide. That's what this line is meant to represent. But for the entire area, including this, the intertidal zone, the one that's both wet and dry at different points during the day, for this entire area, they're subject to special uses. So we have, let's think, physical restrictions. We have almost no restrictions relative to the coastline in this upland area. And then we have, based on some line and designation, usually by some vegetation, we have some restricted uses. And here I have at the federal level, the Clean Water Act, for example, and nutrient restrictions and that sort of thing to protect against, sort of nitrogen loading. There's many issues we could talk about, but the point is there's a number of laws, federal and state. The federal exists uniformly across the nation, and the state laws, of course, are unique to the particular coastal state. But we have these restrictions, and then we move to the sand, and we have even more sort of special uses, permissions and restrictions. And what I mean by that is, in most cases, there are special permissions in this intertidal zone area for the public, for access purposes, that sort of thing. So a private landowner can own, for example, up to, let's say, the high tide line. In most states, most coastal states, they can own up to here. But in a few coastal states, including Massachusetts, you can own to the low tide line. Oh, excuse me, sorry. You can own to the low tide line here. And if you own to the low tide line, you would think one of the most important property rights that you have is to restrict others from accessing your property. The right to deny access, right? The right to exclude, as they say in property law. But in this low tide area, this intertidal zone, places like Massachusetts, you are limited in your ability because of the a number of things that I don't have to get into too much detail, but if those who remember, if you haven't been, we have the public trust doctrine, which public access, basically ensuring public access. So point is, when you get into this area, you have special uses, certain special uses for access and certain special restrictions on what can be done in this area, both for private landowners and for the public. You can't just do anything. There's a number of increasing restrictions for the public good that happen as you start moving from this upland area into what is the vegetation coastal zone area into the sand area. Now, as we get into this, oh, by the way, I should say that the mean low water, this line here, the mean low water mark, MLWM, is the baseline that is identified, not only nationally in the United States, but under the law of the sea. This is what the baseline is defined as the mean low water mark. So that's where all of the measurements, the physical measurements now that occur seaward from this point are the standard measurements that are used for not just the United States, but other countries. Once they've identified their mean low water mark, that baseline then becomes the same baseline for every coastal nation as we start moving seaward to start measuring these additional zones. And there's a lot of different kinds of zones, and you can look at the international law video and under the UNCLOS to get into all of the detailed zones that UNCLOS provides for, because we don't identify all of that nuance here. So we just look at it more sort of, we break it into 3 large areas as opposed to maybe the five or 6 or even 7 areas that UNCLOS talks about in more detail. But you can look at the UNCLOS video if you want more information on that, and that'll be in the link at the end and to the playlist. But so starting here from this baseline for the United States and almost every other coastal nation, we now have another major category or zone, which is up to 3 nautical miles. Here, 3 miles out. Nautical miles are a little bit different than standard miles, but and that's considered state waters. So we have this area that has been defined as state waters, where the state interest is dominant over the federal interest. It doesn't mean that the state can do everything and anything and has no limitations placed on it by the federal government. The federal government still has rights in here and limitations it can place based on the Constitution, rights of navigation and some others. But the state has a lot of rights when it comes to these 3 miles, the first 3 miles from this baseline. And so there's state zoning interests, rights-based uses. This is getting really important today. It's not just resource. And historically, this came from the Submerged Lands Act, which was sort of something called the Tidelands controversy in the United States. But, you know, when we started discovering in the late 1800s, early 1900s, really, offshore oil deposits that were near offshore, states started, you know, particularly California and other coastal states, but California most importantly started leasing these areas to private individuals in order to maximize, you know, the opportunity and also to gain fees, you know, sort of taxing, leasing fees. And of course, the federal government wanted to claim jurisdiction over these areas as well. It was ultimately resolved by Congress in 1953 with the passage of a federal law that said that the states own these resources. So the resources that are contained within this 3 mile limit, which comes from a historical anachronism, by the way, the cannon shot rule, but you can read more about that as to why this would be considered sovereign territory. Why 3 miles? Why not 5? Why not 2? What's up with 3 miles? Again, the cannon shot rule is a key thing to remember there, but there's a historical reason 3 miles originally became something of importance and is still held in UNCLOS today as an international norm. But from that 3 miles, so we have state zoning interests and rights. Then we have 12 miles, by the way, which is this, you know, state, federal, territorial relative to other nations. We have 24 miles, sort of contiguous zone. So there are all of these within this 200 nautical mile. This is where federal zones exist, and there's all kinds of zones. And in the federal zones, you have, you know, oil, gas, recreation, marine protected areas, all different types of zones. So federal identification of marine protected areas. Today, you think of the importance, at least in the United States, but other countries as well, for developing these areas for wind, offshore wind, for example. Many times there are Massachusetts has gone through this, where if it's in state waters, some of the special interests, some people have argued against the placement of windmills for a variety of reasons, because they can see the sight line from the shore. But if I want to site a windmill farm, for example, to farm wind, it's easier for me to site it just in federal waters outside of those 3 miles, because I just have to deal mainly with federal permitting. I still have to deal with the state permitting for, let's say, access cables and that sort of thing, where I have to lay cables underground to carry the electricity. But at least for the siting of the actual facility, it's easier, because if I'm in 3 miles of the shoreline, then I also have to deal with a lot of state interests, and it can get difficult. So there's a plethora, and this is, by the way, not just the United States, other countries as well, but you can understand there's a plethora of issues that are defined. But once we get into this 200 miles or the extent of the continental shelf, when the continental shelf is longer than 200 miles, that's under UNCLOS, then we deal with these federal zones. And in the United States, we have the Federal Coastal Zone Management Act, the CZMA, and that adds additional considerations. The Coastal Zone Management Act provides incentives for states, coastal states, to develop coastal zone management plans. Once those plans are approved, one of the main benefits is that the federal government, when it's doing something in its federal waters that may impact state waters, state priorities, then the federal government has to consider those state priorities that are identified in the coastal management plan prior to taking any action, and should avoid any actions that will have a direct impact. So it's this sort of what we call a reverse supremacy clause, where the federal government normally doesn't have to consider the state's interests, particularly in its own water, but the Coastal Zone Management Act creates special considerations that give states rights in federal actions in federal waters. No rights are absolute, but it gives them a seat at the table. There's more information on this in the CZMA video if you're so interested. But so anyway, we have our state zone, we have our 200-mile where the federal zones are at play, what we call federal waters, and then we have beyond 200 nautical miles or beyond the extent of the continental shelf if it's further, international water. And in international water, we have the internationally agreed zones. The Law of the Sea Convention is usually the LOS or UNCLOS, United Nations Convention on Law of the Sea, and bilateral agreements between nations, where nations that might exist next to each other, where they share interests and they want to make determinations and decisions about how to share a resource. For example, I have a good example in the international law video where I show that two abutting nation, coastal nations there, where they might have a shared resource, a resource that extends over both, how they can think about developing policy that helps both of them, or at least encourages. And also UNCLOS is important in protecting coastal nations that can't engage in full use of because of technological limitations or et cetera, or financial limitations. So protecting their resources from other coastal nations that might want to exploit, just in these areas. So there's a lot to consider there. But what this gives us holistically here is a sense of, look, here are the major zones that apply when we start at the land and we move all the way out into international waters. These are the major zones, and at least in the United States, here are the sort of categories of interest that are at stake. Here are some of the details about, what are these? How do we define these zones? What are they defined as? What are the key characteristics? And again, there's a lot of detail that we could spend a lot of time discussing, and some of that detail is provided in the other more substantive videos that get into more depth. But this should give you a sense of, okay, here's the big picture, and here's some of the basic information or the basic issues that are defined by this picture. So here it is. I hope it's helpful, and thank you very much.